All right, we are now on our next video, which is how do I explain a will to my client? So, as you can see my screen right now, I have two display screens. I have a laptop that sits in front of me so I can see over and see my clients, and then I have another screen that I flip around. It's my dual monitor system, and I flip the other screen around so my clients can see this as I go through and explain the document to. And so the first thing that I do when I go through this with a client is, did I spell your name right? The number one mistake that's going to be made is when they fill out your intake, they're going to, you'll have clients that will misspell their children's name or their spouse's name. It's amazing how many times it happens. Or you misspell the name. So I say, did I spell your name right? Do you live in Collin County, Texas? And you understand that you're revoking all your wills, any will that you've ever created before. And they say, yes, we do that. Did I spell your wife's name right? Did I spell your children's name right? And then I go through each one of these documents. And then I explain to them any reference to my descendants or my children in this will is to the ones identified above. Now, I want to make sure, the other thing I asked them, you have never had any other children born or adopted to you. I'm repeating that again because I want to make sure that they don't have any other children and they just haven't told me anything. And I make sure they understand if you don't put all your children in here, this can affect your estate plan. I explain right here what a memorandum is. A memorandum is that you're going to leave property. You're going to write on a separate piece of property directing the disposition of personal household effects. And I tell them that does not include cash, cars, or real estate. And then I explain to them that in a memorandum, it's not legally forcible here in Texas, but generally it is followed. Burial directions. I usually keep it simple. I say, if someone wants to give you specifics, you can put it in here, but I always put that a location is determined by my executor. The reason why I let the executor decide is because people move around. If you specifically put in where someone's going to be buried, it becomes difficult. This is just identifying that my executor should respect my memorandum, and we're making an additional specific bequest. So understand the difference between specific bequests and the residue. Where does the property go in? A specific bequest comes first. You're specifically identifying a piece of property, and that goes to that person. So if expenses were to happen in an estate, you need to go through your state rules and understand, well, what happens with a specific bequest. If I give a house to somebody and there's a mortgage on the house, well, how is that mortgage? Is it paid off? What's going to happen with that specific bequest? So you need to understand kind of those general concepts. In this specific bequest, I'm giving my wife a life estate because I don't want her future husband to have a nice house. So I'm going to just give her a life estate in the house and say, you can live there for the rest of your life, but once you sell it, then it's going to go according to the residue of the estate. And the residue says it goes to my wife anyway, so I didn't get around it. She gets everything. The residue is like what's left over. So you could list out the specific bequest, and then you get down to the residue, and then you leave whatever's left over. And you say, I'm going to say everything goes to my wife. If she's not around, everything goes to my kids equally. So it goes to my descendants who survived me per capita each generation. That says equally at each generation. Now, you got to understand the difference between per stir piece and a per capita distribution or a hybrid per capita distribution. You just need to go back. And like I said, it's 2 paragraphs long. You can read it. Simple understanding is per capita each generation is just going to leave it equally at each generation. When everybody of a generation has died, the lower generation moves up and they all become equal. So even though you have 3 kids, let's do 2 kids. 2 kids, one had eight children, the other had 1. If both children have died, the grandchildren move up and then they become the children. All right, this was that supplemental needs trust that I talked to you about. I created it with my son in here. Let's just assume that he was disabled and needed it, and it just puts all the language in there. I'm not going to go through that. That's in the trust section that we'll start talking about stuff like this. Executors and trustee appointments. I'm appointing my wife to be my executor and trustee. This would also list out alternative, I would have put it in here. Vacancy in a trusteeship. I'm basically saying that a guardianship can appoint it. Bond. I am going to put into my documents that my executor is serving without bond. A bond, at least in the state of Texas, is a joke. I was talking to our probate judge here in Collin County, Texas, and he said he has been on the bench for 14 years and not one bond has paid out. So that just gives you, it's just a way for insurance companies to make money. They just don't pay out. They're kind of worthless. At least in the state of Texas. It could be different in other places. I would talk to your probate judge and find out. Expenses and compensation. I, of course, usually say no one's getting paid to be the executor. It always causes problems when people get paid unless they're professionals doing it. But if you have one kid doing it and the other ones aren't getting paid, they get upset. Ancillary executors. So you got to remember what an ancillary probate is. That is, you're probating in a foreign jurisdiction from where the will was created. So if I moved to Oklahoma and I never redid my will, I have a Texas will. Well, I'm going to have to do an ancillary probate up there. Actually, I might have misspoke on that. Ancillary probate might be if I owned real estate up there, but I probated down here and I'm doing it up there. Multiple executors and trustees. So if multiple people are serving, this paragraph is going to designate, and I tell my clients that that's what this paragraph is. As you see, I skip some of these paragraphs, but I pretty much go through every paragraph and explain. I'm going through more detail than I would give generally. But I usually go through and explain, well, this paragraph is talking about co-executors working together, guardianship provision. I go, did I spell your guardian's name right? Is that who you want to be the guardian of your children? They go, yes. This is super easy. That in Texas, I go, these are the executor and trustee powers. This is how we create an independent administration in Texas, meaning that the judge no longer has to oversee anything that an executor can act independently. Now, every state has different rules, but we allow, and I tell people, when you see this list number in your will, I'm listing off the powers that you're going to give to your executor, and basically saying to a judge in the future that you trust your executor to do everything. Now, when I see an article heading end up at the bottom of a page, I'm going to move it down. All right? I don't want an article heading that looks sloppy. So make sure it moves down. All right, spendthrift provision. What is a spendthrift provision? Basically, a spendthrift provision is just saying, under no condition is my executor to pay my beneficiaries' creditors. Now, you have to pay your own debts when you die. So your estate will pay your debts, but your children's executor or your children's creditors don't have to be paid, and you can specifically state that. That also can make a trust creditor. So if you have a testamentary trust, meaning a trust in your will, you can make that trust creditor protected by putting this language in here. At least in the state of Texas, you might want to make sure in your state that does that too. Maximum duration of trust. This is a rule against perpetuities. And I really skim that because I'm not going to explain that to my client. And accounting, after I pass away, my trustee is to give an accounting, and a beneficiary can have accounting within 60 days of receiving a written request. This is incredibly important to have accounting measures in there because you want your beneficiaries to be able to keep the executor honest. Survivorship provision. Someone has to live 30 days after you in order to inherit. So if me and my wife get in a car accident, I don't want everything going to her, even though she died a few minutes after me. I want someone to live at least 30 days. And this could have drastic effects. We have a probate case right now where a house was left to son. Son died 31 days after the will. And now the house is going to son, even though he's passed away. Well, that's going to end up going to a granddaughter, which that was not the intent of grandma. And that's why they should have done a life estate to son, but it was poor estate planning done by whoever did it. Payment of debts. I'm explaining how debts are to be paid right here in this paragraph. I just have my own version that I use so I understand it in my head and make sure that it works with my clients. Wills are not contractual. Basically, my wife and I are executing these at the same time. We're not making any agreement that we're going to leave anything to anybody. So this is to prevent from, especially if you have a blended family, a husband dies and he didn't make any agreement with his wife that she had to leave the property that he left her to his kids. A descendant. What is a descendant? I explain what a descendant is by explaining what a descendant is not. A descendant is not the spouse of your children. It is not a step-grandchild. And that seems to clear up, and it's a child adopted under the age of 14. And that seems to generally get across to the people to understand what a descendant is not. If you tell people what a descendant is, well, you might run into this problem. So I tell people it's not a step-grandchild. Do you have step-grandchildren? And then they tell me yes or no. Do you want that child to inherit? I've only had one time in 4,000 estate plans where someone said, yes, I thought that they were going to be included. And we had to fix it right there in that point. But that would have been a disaster because they very much loved their step-grandchild as their own child. The general answer from people is no, they don't want a step because they should be inheriting from their family. Incapacitated, someone's deemed incapacitated cannot be your executor. They can be deemed incapacitated 3 ways. A court says they are, a guardianship is placed over them, or 2 licensed physicians say they are. This is defining what the term heir means. The governing law, of course, I'm going to say is the state of Texas. The right to use principal residence if, because in the state of Texas we have homestead exemptions, tax breaks on personal property. If a trust is created and a house is to go into a trust, you need this language in your will. Now, Westlaw automatically puts it in there for you, but that's why you should use a software. But if you don't use the software, you have to be aware of the fact that you might have property exemptions for homesteads, and you want to continue that even though a house is moving into a trust. Those are concepts that need to be understood. I hope you don't feel like you're being overwhelmed. I'm trying to get the point across that what you really need to do is just use the software, and it will put the things in there necessary to put in. And I'm going to guide you through. Right now we're at level 1. This is basic estate planning. We didn't talk about creating testamentary trusts. As you can see, it gets more complicated as we move forward. But at this basic level, you don't need to worry about a lot of those concepts. And then here's my description of per capita each generation, and then a no contest clause. I tell people we put a no contest clause. If one of your beneficiaries challenges, they can lose their inheritance. Okay? And then we have a 1-page signing in the state of Texas, and then I put a title page. And make sure that your title page has your address, phone number, and we want to make sure people can call you and get a hold of you. But that is how you would describe a will to your clients. And if you do that, if you flip that screen around and you go through what I just went through with you, your clients will love you. They will go, thank you, versus sending them the document and saying, read through it. Well, they'll spend hours reading through it, and you can see I did that in less than 20 minutes.